This video first reviews the process and criteria used by the Kentucky Public Service Commission in determining the appropriate rates for the utilities under its jurisdiction. The presentation then provides an overview of case number 2013-00199, the request by Big Rivers Electric Corporation for an adjustment of rates to reflect the departure of the Century aluminum smelter in Sebree from the Big Rivers system. As with other matters under PSC jurisdiction, rate making is a legal process. It is governed by statutes enacted by the Kentucky General Assembly and by PSC regulations derived from those statutes. Also applicable are legal precedents set forth in PSC orders and in court decisions regarding the application of PSC statutes and regulations. The guiding principle in Kentucky statutes regarding rates is that they must be fair, just, and reasonable. Those terms are not defined in law, but their general meaning has been established over time through precedents and legal interpretation. In applying the statutes, the PSC seeks always to strike a balance between the interests of a utility and its customers. Because they do not have shareholders, cooperatives do not earn a rate of return on investment. However, they are granted rates that produce revenue in excess of expenses. This is so they can maintain financial stability and meet financial requirements set by the entities that extend them credit. Determining rates is a two-part process. It involves calculating a revenue requirement and then establishing a rate design. After a review of the procedural aspects of a rate case, we will look at those aspects of rate making in detail. Utilities must give the PSC at least 30 days notice before filing an application to adjust rates. They also must give public notice to their customers when the application is filed. The procedural clock starts running when the application is filed and determined by the PSC staff to meet all filing requirements. An application cannot be acted upon until it is complete. The applied for rates cannot go into effect until 30 days after the application is filed. However, in practice, the PSC may, and usually does, suspend the rates for 5 or 6 months to allow for a thorough review. If the PSC does not issue a decision before the suspension period ends, the utility may put the rates into effect pending a final decision. But if the PSC ultimately grants rates lower than those requested, the utility must refund the overcollection to customers with interest. The PSC has 10 months from the time the application is filed to complete its consideration of the rate application. Once a final order is issued, any requests for reconsideration must be filed within 23 days of the order. Interveners are parties other than the utility that play a formal role in the proceedings before the PSC. By law, only the Kentucky Attorney General has the absolute right to intervene in cases before the PSC. Kentucky statutes designate the Attorney General as the representative of ratepayers as a whole. Other parties may petition the PSC to become interveners. In order to be granted full intervention, a party must show that it represents a unique interest not represented by the Attorney General, and that it will be able to bring forth evidence that might not otherwise come to the attention of the PSC. Parties granted full intervention are allowed to introduce testimony, ask written questions of the applicant and other parties, and participate in the cross-examination when the PSC holds its formal evidentiary hearing in a case. Examples of parties granted full intervention include groups representing interests such as large industrial customers, low-income residential customers, and environmental advocacy groups. Parties may seek intervention once a utility gives notice that it will file a rate application. The application includes direct testimony by witnesses who will appear at any hearing held by the PSC. Just like direct testimony in a court proceeding, this pre-filed testimony is taken under oath, and any perjury is subject to penalties under the law. The same is true of any testimony filed by interveners. After the application is filed, there may be one or more rounds of written questions, known as data requests, between the parties. The PSC staff also files data requests. Responses to data requests are made under oath. The PSC is not required to conduct local meetings solely for the purpose of taking public comment, but may do so at its discretion. With or without public meetings, public comments are always welcome and will go into the case record for the Commission's consideration. They may be submitted by mail, fax, email, or through the PSC website. An evidentiary hearing is not required, but is customarily held in major rate cases. It is conducted much like a court proceeding. Although testimony is usually filed in writing in advance, witnesses appear under oath and are subject to cross-examination by counsel for other parties, by the PSC staff, and by the commissioners themselves. In complex cases, hearings may last several days. All PSC hearings are open to the public and are webcast on the PSC website. After a hearing is concluded, the PSC may ask for additional evidence or for briefs from the parties summarizing their positions. The PSC then takes the case under advisement. Decisions are rendered in writing in the form of a final order. A decision requires agreement by at least 2 commissioners. Cases sometimes are settled in advance of the PSC hearing. When that occurs, the PSC will conduct a hearing on the proposed settlement. In order to be considered by the PSC, a settlement must be unanimous. In other words, all parties to the case must agree on all issues in the case. However, partial settlements, known as stipulations, are permitted. In such cases, all parties agree on one or more issues, leaving the remaining issues to be decided by the PSC. Settlements typically set forth a final result without detailing the compromises involved in reaching that result. For example, a settlement often will produce a proposed rate structure without providing the underlying calculations by which it was derived. However, in order to accept a settlement, the PSC must still evaluate the final rates, and they must meet the test of being fair, just, and reasonable. The PSC has the right to accept, reject, or modify a settlement. Now let's look at the 2 fundamental calculations used to determine rates. The revenue requirement is the total revenue a utility needs to maintain safe and reliable service and financial stability, and in the case of investor-owned companies, offer its shareholders the opportunity to earn a reasonable rate of return on equity. Revenue requirement is based on a 12-month period known as a test year. If it is a backward-looking or historic test year, the 12-month period must end no more than 3 months before the filing date of the application and uses actual financial information for the period. Forward-looking or forecasted test years are prospective 12-month periods that begin at the end of the suspension period. Because forecasted test years are more complex and require more review, the suspension period mentioned earlier is 6 rather than 5 months. To calculate a revenue requirement, the first step is to determine a utility's allowable expenses. These include routine minor construction, equipment and material purchases, operational costs including maintenance, billing, customer service, and others, personnel costs such as salaries and benefits, the cost of major construction projects once they go into service, and any borrowing costs. Certain expenses are not allowed. Advertising for promotional purposes is excluded by law. Executive bonuses, employee gifts, and similar expenses are typically not allowed. Charitable donations and club memberships are excluded. The PSC also has broad discretion to exclude any expense it deems unreasonable. Unusual or one-time costs or revenue are excluded from the test year so that they do not distort the revenue requirement. They are instead accounted for separately and spread out over time. Unusually high storm recovery costs may be excluded. Revenue from asset sales also may be excluded. Note that operating expenses are recovered based on actual cost without markup. The final revenue requirement includes all of the allowable expenses and a calculation that sets the amount of additional revenue needed to meet financial requirements. Certain utility expenses are not incorporated into the revenue requirement and thus are not reflected in base rates. These include, for electric utilities, fuel costs above or below the amount included in base rates. These appear as a separate surcharge or credit on the bill. For gas utilities, the commodity cost of gas. It appears separately on the bill. Environmental compliance costs for coal-burning electric utilities. These appear on the bill as a surcharge. Energy efficiency programs for electric and gas utilities. These costs also are recovered as a surcharge. Surcharges to pay for assistance programs for low-income customers. Costs assessed by other entities, such as city or county franchise fees or local taxes. Once a revenue requirement, the total revenue a utility needs to operate and maintain financial stability, is determined, the second step in the rate-making process is rate design. This process allocates both costs and revenues over various rate classes, including residential, commercial, and industrial categories. As part of a rate application, utilities submit cost of service studies that allocate costs over the various rate classes. In general, larger customers have lower costs of service due to economies of scale. Thus, the cost of service typically is highest for residential customers. Rate design also examines fixed versus variable costs. Fixed costs are those that do not vary with consumption, such as meter reading or customer service. Variable costs are those driven by usage. The PSC uses cost of service analysis as a guideline, but rates are not set strictly in accordance with the cost of service. Thus, large industrial customers, even if they pay lower rates than residential customers, typically pay rates higher than their cost of service would indicate. Conversely, residential rates do not fully recover the cost of serving those customers. The PSC typically does some rebalancing of rates in each rate case, both in terms of fixed and variable rates and allocation across classes. But those adjustments are done in small increments in keeping with the PSC's long-standing policy of gradualism in moving toward fully balanced rates. Now we will look at Case 2013-00199, the pending rate case filed by Big Rivers Electric Corporation. But before getting into the specifics of the pending case, it might be helpful to review the sequence of events leading up to it. In August of 2012, Century Aluminum filed notice, as required in its contract with Big Rivers, that it intended to shut down its smelter in Hawesville in August of 2013. In January of 2013, Big Rivers filed a rate case application seeking to adjust rates to compensate for the loss of revenue from the Hawesville smelter, which was at the time its largest customer. Also that month, Alcan filed a one-year closure notice for its smelter in Sebree. In June 2013, Big Rivers and Kenergy, the distribution cooperative serving Hawesville, filed for PSC approval of a contract setting out the terms under which the Hawesville smelter would remain in operation, but would no longer buy power from Big Rivers, although it would continue to use transmission lines owned by Big Rivers. Also in June, Big Rivers filed the rate case, which is now pending before the PSC, seeking to adjust rates in response to the loss of revenue from the Sebree smelter. In August, the PSC approved the contract pertaining to the Century smelter in Hawesville, which then exited the Big Rivers system. Big Rivers then put its first proposed rate increase into effect as allowed under Kentucky statute, but those rates were still subject to change by the PSC. In October, the PSC did in fact change those rates, adjusting them downward and ordering Big Rivers to refund the over-collected amounts with interest as required by law. After several parties to the first rate case requested the PSC to re-examine certain issues, the PSC in December 2012 granted a rehearing on one of those matters. Thus, the first rate case remained before the Commission while it continued its review of the second rate case. Also in December, Big Rivers and Kenergy submitted for PSC approval a contract to allow the Sebree smelter, which earlier in the year was purchased by Century, to obtain market rate power in a manner similar to Century's Hawesville facility. Now let's look at the pending rate case in more detail. It was filed on June 28, 2012, which puts the end of the suspension period on January 28, 2013, at which point Big Rivers can put the proposed rates into effect, subject to refund. A PSC decision must be rendered before the end of April, but is likely to come sooner. Big Rivers is requesting additional revenue of $70.4 million. That would partly offset the $175 million in annual revenue that will be lost when the Sebree smelter exits the system at the end of January. The Sebree smelter currently uses about 40% of the total power generated by Big Rivers for its customers and accounts for nearly half of the utility's current revenue, which was substantially reduced earlier by the exit of the Hawesville smelter. Based on information provided by Big Rivers in its application, the estimated impact on monthly electric bills for residential customers served by one of the three Big Rivers distribution cooperatives would be 21.5%. Depending on the individual cooperative, that means an increase of around $25 or $30 per month from the current average of about $143. Large industrial customers in the Big Rivers system would see rates increase by about 25%. However, those rate increases might not take effect immediately. Big Rivers has proposed to delay the increases by tapping into reserve accounts established during the 2009 transaction that returned control of the Big Rivers power plants back to the utility prior to the expiration of a lease agreement with an independent operator. The purpose of the accounts was to mitigate the impacts of future rate increases. Big Rivers estimates that, if its rate increases take effect as proposed, the reserve accounts would delay the rate increases for industrial customers until July of 2014 and residential customers until April of 2015. Those estimates would change if the PSC approves rates different from those proposed by Big Rivers. In addition to seeking rate increases, Big Rivers is taking several steps to compensate for the loss of the load and revenue from the aluminum smelters, which had been its two largest customers. It plans to close the Wilson Power Plant in February 2014. The Coleman Power Plant in Hawesville is due to close in mid-2014, but its closure date will be determined by the requirements of the regional transmission grid operator. The plant is currently being kept operational due to grid stability requirements. The cost of operation for grid stability purposes are not being borne by Big Rivers customers. Because the Big Rivers situation is complex, it is important to remember what aspects are addressed in this case and which are not. The contract regarding power supply for the Sebree smelter is a separate matter before the PSC, although its financial ramifications are part of this proceeding. Nor does this case address issues that are being revisited in the first rate case. Several parties are interveners in this proceeding, as they were in the first rate case. The Kentucky Office of Attorney General is representing the ratepayers as a whole. The Kentucky Industrial Utility Customers, Inc. is an organization representing several of the industrial customers. The Sierra Club is an environmental group. Also intervening are the three distribution cooperatives that both own and purchase power from Big Rivers. The evidentiary hearing in this matter, which will take place at the PSC offices in Frankfort, is scheduled to begin at 10 a.m. on Tuesday, January 7, 2014. However, it may be delayed somewhat if the hearing on the Sebree smelter contract, scheduled for Monday, January 6th, cannot be concluded in a single day. As with all PSC hearings, both the smelter and rate case proceedings may be viewed live at psc.ky.gov. Public comments will be taken at the start of the rate case hearing, as well as at the start of the smelter contract hearing. A public comment session in the rate case is scheduled for 10 a.m. Eastern Standard Time or 9 a.m. Central Standard Time on Wednesday, January 8th. It will be linked by video conference to locations in Paducah, Owensboro, and Brandenburg, allowing people in those areas to address the PSC directly without having to travel to Frankfort to do so. As is always the case, the PSC is accepting written comments in this matter. Here is how to submit written public comments. Including the case number in your comments will ensure that they are placed into the case file as quickly as possible. Here is how to get more information.